mute your microphones and listen attentively.
Okay, sir.
Judgment. These are consolidated suits, the summaries of which are that the claimants were employed at various times as student nurses by the government of Imo State through its Public Service Commission, Owerri, in 1979. They were respectively issued with instruments of employment to that effect and posted to the nursing school at Ramat Specialist Hospital, Umuahia, now in Abia State. Subsequently, the claimants acquired their respective or their requisite qualifications as registered nurses between 1982 and 1983. Upon gaining these qualifications, they were then employed as staff nurses and were each issued with letters of temporary appointments in that regard. The first and third claimants were eventually posted to work in General Hospital in Uzuakoli, while the second claimant was posted to the Queen Elizabeth Specialist Hospital, Umuahia. They all got their letters of confirmation of their respective appointments. Hitherto, the hospitals where the claimants were posted to were all under the control and management of the Health Management Board of Imo State prior to their takeover by the federal government of Nigeria. In 2013, the claimants were accordingly directed via separate letters dated the 3rd of May 2013 by the management of the first defendant to report at the National Pension Commission's office for the purpose of completing their compulsory retirement forms and to update their records. In 2015, however, they were accordingly stopped or prevented from performing their duties as nurses on the basis that they had served the government for 35 years and so became due for compulsory retirement from service, since they were initially appointed as student nurses in 1979. Upon failing to successfully appeal against what they believe are undue and untimely retirements, the claimants approached this court for redress of this action, which were purportedly orchestrated by the defendants. The defendants, of course, deny all these bogus claims. Now I'll go straight to the decision. Court's decision. Court's decision. You may mute your microphone. You may mute your microphone.
Yes, my lord. I'm hearing you, my lord.
Yes, you can offer. I'm going straight to the court's decision now.
Yes, sir.
I carefully.
My lord, I'm here.
Yes, I know. The defendant's counsel has already adopted your final written address.
Yes, sir.
So you mute your microphone so that I can continue with the judgment.
Come. So I show you microphone properly.
Mute it. Off your microphone. Mute it. All right. I carefully perused all the processes filed in this suit, analyzed the evidence produced by the parties, listened to and deeply pondered on the witnesses' testimonies, both in chief and under cross-examination, examined the laws as guide, and considered the final written submissions of learned counsel for the parties. I believe that one issue which is akin to the one formulated by counsel for the defendants and the sole issue raised by counsel for the claimants are materially and substantially similar, whereas issue 2 of the defendant's counsel submissions needn't be isolated as same is captured under his issue 1. Hence, for the purpose of this judgment, the court is convinced that the sole and all-encompassing issue for determination should be whether from the pleaded facts and evidence adduced on both sides, the claimants have proven their case to be entitled to the reliefs sought in this suit. I shall determine this sole issue on the strength of the facts before this court, which are tied to all the evidence adduced by the parties. Being that this suit is consolidated, the facts are similar in nature, but the claims made by the respective claimants will be distinguished at the point of making my final pronouncement. It must, however, be observed that there are some sets of facts which are undisturbed and undisputed in this case. The claimants and these defendants agree on the following facts. 1, that at different times in 1979, these claimants were variously interviewed by the Public Service Commission, Owerri, and offered appointments as student nurses at the Ramat Specialist Hospital here, as the first student. 2, that the first, second, and third claimants became qualified as registered nurses in 1982 for the first claimants and in 1983 for the second and third claimants respectively. 3, that upon their qualifications as registered nurses, these claimants were each served with letters of temporary appointments as staff nurses and subsequently served with letters of confirmation of each appointment. And lastly, 4, that the claimants' employments are regulated by the public service rules of the Federation. Suffice to state that the kernel of this suit, from the existing facts before this court, is whether the computation of the claimant's years in pensionable service should be done from their first letter of appointment, which was in 1979, when they were employed as student nurses, or from their second and subsequent employments as full-time staff nurses in 1982/1983, as the case may be. This suit was battled by the parties since 2015 within the sphere of this just one question. Meanwhile, it is necessary to state that in all civil suits, such as this one, the onus of proof is statutorily placed on the claimant. This is because he is the assertor who initiated the suit against the defendant. Therefore, the claimants must first establish by credible evidence that they are entitled to their reliefs before the onus propandi will shift to the defendants. Elucidating on the nature of the duty on the litigant to establish his claims, the appellate court in Aliu and others versus Yola and others, citations supplied, have stated that the burden is on the plaintiff to establish his claims, etc. You may see sections 131 and 132 of the Evidence Act 2011, which are apposite to what has just been stated. This notable legal foundation underscores the duty on the claimants to prove their case on the strength of credible evidence. I observed earlier in this judgment that the claimants' counsel argued that the claimants actually proved their claims and that they are entitled to the reliefs sought in this suit. The claimants' counsel had submitted that the claimants' evidence are unchallenged and uncontroverted insofar as DW1, who is the defendant's sole witness, testified on the cross-examination that he read and signed his statement on oath in his lawyer's office. Learned counsel submitted that the defendants have no other evidence before this court to rely on in rebuttal of the claimant's claims, since the statement on oath adopted by DW1 as his statement in chief is invalid and unacceptable in law. He cited numerous legal precedents to support his argument. In opposition, on the strength of the decisions of several decisions also, learned counsel for the defendants distinguished between what an affidavit is and a witness statement on oath, and to also submit that any objections to any statement on oath must be made before it is submitted by a witness, and not when it must have been taken as an evidence in chief. Now, from the testimony of DW1, it is beyond sure that he testified to signing his sworn deposition in his lawyer's office. Going by the rules of this court, it is required of a litigant, the claimant especially, to accompany his filed writ of complaint with a statement of facts establishing the cause of action, a list of witnesses to be called, written statements on oaths of all the witnesses listed by him, etc. You may see Order 3, Rule 9 of the rules of this court. In the same vein, a defendant who wishes to file his defense to the complaint is required to accompany his statement of defense with a written statement on oath of all the witnesses listed 12 and all processes. You may see Order 15, Rule 1 of the rules of this court, 2017. While I agree with the submissions of learned counsel for the defendants on the uniqueness of affidavits and sworn depositions, I deem it pertinent to also note that both affidavits and depositions on oaths are subject to the Evidence Act 2011 and the Oath Amendments Act, Cap 01 LFN 2014 or 2004. Therefore, respecting the question before whom an affidavit or deposition on oaths can be made, Section 10, Sub 1 of the Oaths Act provides as follows, and I quote, "It shall be lawful for the Chief Justice of Nigeria, a Justice of the Court, the President of the Federal High Court, a Notary Public, and any Commissioner for Oaths to administer any lawful oath or to take any lawful affirmation or affidavit which may be required to be taken or made for the purpose of complying with the requirements of any law for the time being enforced throughout Nigeria or elsewhere, except where such procedure is expressly or by necessary implication manifestly excluded by the terms of such law as aforesaid, and the presumption shall be against any such exclusion." End of quote. Now, Section 111 of the Evidence Act, however, provides that the fact that an affidavit purports to have been sworn in the manner prescribed in the preceding sections of the Act shall be prima facie evidence of the seal or signature of any such judge or court or magistrate or any such officer or person mentioned in or appended or subscribed to any such affidavit, and the authority of such court, judge, magistrate, or other officer or person to administer oaths. Furthermore, the Act provides in Section 112 as follows: "An affidavit shall not be admitted which is proved to have been sworn before a person on whose behalf the same is offered, or before his legal practitioner, or before a partner or clerk of his legal of his legal practitioner. End of quote.
He has entered.
Please mute your microphone. I must acknowledge that in recent times, questions on the validity and admissibility of sworn depositions which were taken contrary to the provisions of the law have been copiously pronounced upon by the courts. In 2008, the opportunity unveiled itself at the apex court. There are interruptions in the background. Interruptions in the background. Please mute your microphone. Please mute Maureen Onosike. Mute your microphone, please. Please mute your microphone. Maureen Onosike, mute your microphone or you'll be held in contempt. You will be held in contempt. I'll take that again. I must acknowledge that in recent times, questions on the validity and admissibility of sworn depositions which were taken contrary to the provisions of the law have been copiously pronounced upon by the courts. In 2008, the opportunity unveiled itself at the apex court in the case of Buhari versus INEC, citation supplied. There, the respondent in the election petition at the Court of Appeal had challenged the validity of the appellant's witnesses' deposition on oath. The said depositions on oath were said to have been taken before a notary public, one Val I. Esquire, who had also appeared as counsel in the suit as one of the petitioner's counsel. The deponents, the depositions were, however, admitted subject to the right to raise objections to the admissibility at a later stage in the proceedings. Eventually, the appellate court held it earlier that in view of the provisions of Section 83 of the Evidence Act, which is now Section 112, and Section 19 of the Notary Public Act, Cap 331 LFN 1996, the said Notary Public, that is Val I. Ikonu Esquire, being a practitioner's or the petitioner's counsel, lacked the competence to notarize any documents that were used in the proceedings. However, at the apex court, the appellant rehashed this argument again in much the same tone as the learned defendant's counsel in this suit, stating that there is a difference between an affidavit contemplated under the Evidence Act and a witness statement of oath. And also that upon being sworn and adopted before the court, a statement of oath might have been cured of all irregularities. Also, it was further argued that any objection to the validity of a statement on oath must be raised before it is adopted by the witness and not after it had been adopted. Upon considering the submissions of the counsel there, that is at the apex court, they upheld the decision of the Court of Appeal and stated as follows, quote, learned senior advocate has submitted that Section 83 anticipates what he called the latter affidavit and not a procedural deposition, which is normally sworn to at the adoption. Unfortunately for the appellant, Section 83 does not draw any such cleavage or dichotomy. What does learned advocate, senior advocate, mean by the expression procedural deposition? Does this infer that there is a substantive deposition? Depositions are all matters of procedure as they are adjectival in nature and content. So accordingly, the question, which is question A, fails. End of quote. I am not unaware of the case of Biu versus Dahiru, citation supplied, relied upon by learned counsel for the defendants. In that case, the respondent's witness had testified that he signed his deposition on oath at the respondent's office. The trial court nonetheless considered the said statement on oath of that, I take that again. The trial court nonetheless considered the statement on oath of that of the witness, and when the same issue arose for consideration at the Court of Appeal, the appellate court, whilst of the view that the authority of Owerri versus INEC was distinguishable from the instant suit of appeal, held inter alia that a witness's deposition on oath should not be subjected to stringent conditions as an affidavit. Excuse me. It was held that a witness deposition should not be as sacrosanct as an affidavit, and that a statement on oath being adopted on oath before the court should be weightier than an affidavit, and the oath taken in court cures it of any defective formality. However, in 2022, which was just last year, the appellate court once again considered a similar issue in Umar versus Katagum and another citation supplied. Here, PW1 testified on the cross-examination that his statement on oath was deposed to in his lawyer's office. Resolving the issue on this, the Court of Appeal, whilst relying on Buhari versus INEC, Supra, among others, held inter alia. And I quote, thus, therefore, PW1's witness statement on oath, having failed to comply with the provisions of Section 112 of the Evidence Act and Sections 10 and 13 of the Oaths Act, and the decision of the Apex Court in Buhari versus INEC and plethora of decisions of this court, PW1's witness statement on oath and all documents attached thereto are hereby expunged from the records of this court per DZ Senchi JCA at pages 43 to 46. In Hali Aliyu versus Bello Bulaki, citation supplied, the law is now well settled beyond any reproach that a witness statement on oath signed in the chambers of a court or of a council is null and void and of no effect. Such a witness statement on oath is unreliable for the use in the proceedings before the court. This is because a witness statement signed in the chambers of a council has violated the Evidence Act, Oaths Act, and the provisions of the Notaries Public Act. So, the witness's statement on oath, which is required to accompany the originating processes as envisaged by the provision of Order 3, Rule 9 of the rules of this court, is akin to a deposition in an affidavit, in that both depositions in an affidavit and as a witness's statement on oath are simply statements of a witness made under oath, but outside of a court. A global view of the provisions of sections 112 and 1174 is that for an affidavit to be admitted in evidence or allowed to be used as evidence, it must not only be sworn before a person so authorized or to administer the oath, such as a commissioner for oath or a notary public, it must also be signed in the presence of such an officer. In the case of a notary public to which legal practitioner belongs, in the case of a notary public to which legal practitioner belongs, Section 19 of the Notaries Public Act, Cap 141 of the laws of the Federal Republic of Nigeria, 2004, comes into play. It provides that no notary public shall exercise any of its powers as a notary public in any proceedings or matter in which he is interested. This is so because a deponent's legal practitioner is a person interested in the proceedings and therefore disqualified from notarizing for his client. though the legal practitioner in whose chambers the depositions were sworn is or may be a notary public, being a legal practitioner representing the defendant in this suit, he is precluded from notarizing any documents for him for use in the case. So there is no doubt that the current trend in our jurisprudence is to lean towards doing substantial justice and disregard technicality. However, where a matter has been settled by the apex court, the decision of the apex court becomes binding on this court and other subordinate or immediate appellate courts. It must be made clear that this court possesses no powers whatsoever to depart from or ignore the position taken by the apex court on the same or similar facts. Doing so will amount to overruling the decisions of the apex court and the Court of Appeal. This court will not embark on such futile rapscallion exercise. This court, having not been shown that the decision in Owerri versus INEC is overruled by another subsequent decision of the apex court, cannot depart from the said decision. It is binding on this court and must be applied appropriately, and I so hold. Now, it is also judicially established that where there are conflicting decisions of a superior court, the lower court is bound to follow the most recent decision. Hence, this court is bound to also follow the decisions of the appellate court in Owerri versus Katagum and another, which is the latest in time and much more similar in facts with the instant suit, more so as the opinion taken by the Supreme Court remains the authority on the issue. It is unfortunate that there is nothing this court can do other than to follow the law. This court, by the doctrine of stare decisis, is duty-bound to follow the decisions of the apex court and that of the Court of Appeal. Dancing on the heels of the decisions already expounded, therefore, I am propelled by legal conviction to accept the view that the statement on oath by the DW1, which he admitted was deposed to and signed in the office of the defendant's lawyer, is defective, invalid, and inadmissible. Same is, as well as all the documents tendered through DW1, jettisoned and expunged. It should be understood that this court decided not to adopt the decision of the Court of Appeal in Victor Idigbe versus UBA, citation supplied, which was delivered on the 14th of April 2022 by Amadi JCA, which legitimizes the application of Section 12, Sub 2B of the NICA Act 2016, whenever necessary by this court, to depart from a strict application of any provisions of the Evidence Act, where doing so will cause an injustice to a party or promote undue technicality in arriving at a decision. Not only is this not sought for by the Defendant's Counsel, this court is faced with a question that was already directly decided upon by the apex court, which is ultimately binding on this court to adopt and apply without excess. Excuse me. Given the bare principles of stare decisis. I am not unaware also of the decisions of this court, like the one in Arize Okeke versus Arab Contractors and one other, citation supplied by Aro Shegbe J, in which my own learned brother resolved not to expunge the claimant's sworn deposition, despite that it was sworn to before the deponent's lawyer. That case was dealt with according to the peculiarities of its facts and circumstances. Having thus expunged the sole evidence of the defendants, this court is constrained to proceed to consider the merits of the claimant's case vis-a-vis the reliefs sought in this suit. It is right that a litigant who seeks declaratory reliefs shall only succeed on the strength of his case and not on the weakness of the opponent's defense. I do not agree with the submission of learned counsel for the claimants, which supposes that since the defendants do not have any statement on oath, it automatically translates to the claimant's victory. The claimants still have to prove their case by credible evidence. It was established in the earlier stages of this case that the claimants had to undergo training and acquire special nursing certifications before they could qualify as staff nurses. CW3 particularly testified under cross-examination that without her certification as a registered nurse, she would not have been qualified to be employed as a staff nurse. Nonetheless, the claimants maintained that their second letters of temporary appointments as staff nurses represent fresh and new appointments rather than a continuity of their initial appointments as student nurses, contrary to what the defendants want this court to believe. Each of the claimants stated on the cross-examination that there was a break or intermission in their employment before they were temporarily appointed as staff nurses. Interestingly, when asked when the break periods were, CW1 referred to a period between May 1983 and September 1983 as the break period. The CW2 referred to a period between April and August 1982 as the break period, while the CW3 referred to a period between November 1982 and June 1983 as the break period. Respecting their emoluments prior to their appointments as staff nurses, CW1 testified that she only received stipends as salary. CW2 testified that she received basic salaries without allowances, while the CW3 stated that she received allowances but not salaries, leave allowances, or any other benefits. Respecting the claimants' salaries as student nurses, Exhibit C14, third claimant's notification of appointment as a student nurse is quite luminous, and I make quick to reproduce paragraph 2 of Exhibit C14 hereunder as follows, and I read, 2. The following conditions will apply. Effective date of appointment, 29th October 1979. Salary scale, grade level 04. Entry point, 1,320 Naira, I believe is per annum, PA. Increment date, 1st November, ... End of quote. Exhibit C14, without ado, is at variance with and clearly contradicts the claimant's common positions that they were not paid salaries while serving as student nurses. Thus said, I must clarify that the claimants and defendants are in agreement on the fact that the public service rules regulated the claimant's employment at all times material to this suit. As such, the following provisions of the public service rules are instructive on the issue under consideration. These are: 1. Rule 020202, direct appointment to the federal public service may be in any of the following categories. A, as trainee or pupil. B, on probation in a pensionable post. C, on non-pensionable contracts to a non-pensionable post or against a pensionable post for a specific period. And lastly, D, on temporary basis other than C. When the post proves difficult to fill, they shall normally be advertised. Now, the literal canon of interpretation of statutes presupposes that where the language of the legislature is plain and unambiguous, the court shall attribute to them their regular and ordinary meanings. I believe these rules are plain enough and less likely to be misconstrued. The claimants were appointed as student nurses. The term student is defined by the Cambridge Dictionary to include a person who is learning at a university or college. On the other hand, the term trainee is defined by the same Cambridge Dictionary to include a person who is learning and practicing the skills of a particular job. Rule 010103 defines a trainee as a person appointed to a training post in any grade, and it includes a pupil. I find these two terminologies, which is student and trainee, as synonymous words within the context of qualifying a person who is in the process of learning a particular profession. Now, the claimant's appointment letters as student nurses read in part, and I quote, "The Commission has decided to offer you appointment as student nurse in the School of Nursing, Ramat Specialist Hospital, Owerri. See Exhibit C7B. There is no gainsaying that the claimants, by their initial letters of appointments, were placed under the trainee category of employees, which is as envisaged under rules 020202A of the Public Service Rules. Indeed, after their initial appointments as student nurses, they subsequently sat for an examination before they could qualify as registered nurses. This is the only way they could become staff nurses of the hospital. Again, Rule 020203A of the Public Service Rules, or PSR, is instructive and directional on the correct issue. The provision reads as follows, and I quote, "When a candidate for employment requires additional professional experience before he can be regarded as fully qualified for appointment to a specific post, the candidate may be appointed as a trainee or pupil for a normal service of 2 years in that post. This period, however, be reduced in special circumstances, may be reduced in special circumstances. On completion of the training period, the pupil may be appointed to the full grade on probation and will not be eligible for confirmation in the service until he or she has fulfilled the conditions laid down in Rule 020203, where applicable." End of quote. Juxtaposed with the facts of this suit, one would be tempted to conclude that the provisions of 020203A of the PCR substantially resonates with the facts of this case. However, this court is inclined to scrutinize the claimant's evidence for more comprehensive determination of the issue at hand. The claimants tendered in evidence, Exhibit C7C, Exhibit C1, and Exhibit C15, which are the first, second, and third claimants' letters of temporary appointments, respectively. They are dated the 4th of August 1982, 30th of September 1983, and 30th of June 1983, respectively. These exhibits are similar in their contents and intentions. And so, for clarity of emphasis, I shall reproduce the body of the letters hereunder, and I quote, I am directed to refer to your recent posting to General Hospital Uzoakoli and to inform you that you have been offered temporary appointment as staff nurse on salary grade level 07, step 1. That is 2,832 naira per annum, underlined for emphasis. Now, although exhibits C7C and C15 for the first and third claimants read General Hospital Uzoakoli as their primary place of posting, exhibit C1 for the second claimant reads Queen Elizabeth Specialist Hospital instead. These documents speak for themselves, as this is the reason why documentary evidence is celebrated as the best evidence. Now, examining these pieces of evidence thoroughly, I am immediately attracted to the line that reads as follows. I quote, I am directed to refer to your recent posting to General Hospital Uzoakoli. End of quote. This expression is indeed salient in my view. I actually believe that the reference to the recent posting, in quotes, as contained in that line, addresses the fact that a posting was hitherto made and took effect before the making of those letters to signify their appointments as staff nurses, Exhibit C7C, Exhibit C1, and Exhibit C15. In other words, the postings under reference predated the issuance of letters of temporary appointments as staff nurses. So think of a person posted to a duty post before his or her empty seems anomalous and incoherent to me, as only someone already in a valid employment can be posted or transferred to a duty post. Therefore, in the instance suit, it is not out of place to presume that there was some kind of valid and subsisting employments between the claimants and their employers, which formed the hanger for which the postings referred to in Exhibit C7C, C1, and C15 were effected. Although the claimants remain resolute with their contentions that there was a break or intermission in their respective appointments before their temporary appointments as staff nurses were done, these do not impress me in the face of the evidence before this court. So, on the validity or otherwise of the dates of first appointments in the upper forms, which the claimants individually filled out throughout their service years, each of them as CW1, CW2, and CW3 admitted under cross-examination that they filled in 1979 as their year of first appointment in service in their various CSARPER forms, otherwise known as CSA or SAPA, or simply upper forms. However, they each went on to testify that they did not fill in 1979 willfully. The CW1, that's the second claimant, particularly stated that the form SAPA was always returned back to her whenever she filled it, or whenever she filled in the year 1983 as her first year in service. CW2 stated that she was compelled to write 1979, while CW3 detected that she wrote 1979 out of duress. Exhibits C11 and C12 are copies of the SAPA for the years 2011 and 2013 respectively, which were tendered through CW2, that is the first claimant, by the defendant's counsel. I can see boldly written on each of them the date 27th March 1979 in the column provided for the date of first appointment in service. Meanwhile, there is nothing before this court to show that these claimants were ever compelled to fill in the year 1979 as their first year in service at the first defendant hospital. What is even curious is that for the over 30 years spent by these claimants in service, there is nothing before this court to suggest that they, at any point in time, complained or formally complained to any of the defendants for purportedly compelling them to fill in their SAPA forms a date which they believe was not their actually entrance date in service. It is even more disturbing that CW2 testified under cross-examination that she was already a qualified lawyer as of 2013 when she filled Exhibit C12. So she knew the implication of all that. Equity only aids the vigilant and not the indolent. The same CW2, like the other two witnesses, admitted to filling in the year 1979 as their first year in service in her pre-retirement form when they went with other employees to PENCOM. What I find incredulous is that CW2 further testified under cross-examination that the defendants also forced her to fill in 1979 at PENCOM as her first year in service. I mean, what could be more ludicrous? It is imperative to remember that the minimal standard of proof expected of the claimant's claims is to be determined on a balance of probability. Section 131 of the Evidence Act. Their task is thus lesser, having jettisoned the defendant's evidence in total. But in spite of that, I'm still convinced that the claimants were actually employed as student nurses under the category of trainees or pupils in 1979. And upon qualifying in 1982/83 as certified registered nurses and issued with temporary appointment letters to the position of staff nurses, they were subsequently confirmed as employees of the first defendant in accordance with the recognizable public service rules, which were similar to the current one at the time of this judgment. It therefore follows that these claimants were already in public service prior to their temporary appointments as staff nurses and bound by the provisions of the public service rules. Thus, respecting the retirement of public officers, Rule 020810 of the Civil Service Rules 2008 provides as follows, and I quote, 1. The compulsory retirement age for all grades in the service shall be 60 years or 35 years of pensionable service, whichever is earlier. 2. No officer shall be allowed to remain in service after attaining the retirement age of 60 years or 35 years of pensionable service, whichever is earlier. The language of the law here is shall and carries with it a compulsory application. These claimants entered public service and became public servants in 1979 in virtue of student nurses, that is trainees. Their contention that the period of time working as student nurses ought not to be considered in calculating their retirement year is a perfidious attempt to infract the PSR, which clearly determines that no public servant shall exceed the prescribed period of 35 years in service or upon attaining the age of 60 years. Their respective status as trainee or pupil student nurses is recognized by the PSR and must be reckoned with in the computation of their years in service. And I so hold. Flowing therefore from the above findings by this court, it is my honest belief that the first, second, and third claimants, having been duly employed as student nurses into the public service on the 23rd of March 1979, 24th of October 1979, and 24th of October 1979, respectively, had already served for 35 years by the year 2014, and thus due for compulsory retirement in line with PSR 2008, and I so hold. As such, the sole issue for determination in this judgment is resolved against these claimants and in favor of the defendants. Consequently, the claimants' suits fail in their entirety and same are hereby dismissed. Judgment is entered accordingly. Parties are to bear their respective costs. That is all. Yes, court clerk.
Yes, my lord. My lord, that will be all for today.
My Lord, we are grateful.
All right.
Thank you, sir.
Okay. Oh, yes. Are the council still there?
Yes, sir.
Sir, we are-
Chief Chioye,
My Lord, we are
do
grateful.
you appear alone? You appear alone.
Now, I clear my learning
Yes,
friends.
please. Chief Chioye, what's your initials, please?
G.I. Chionye. G.I. Chionye.
Okay. Chief. Okay.
With
Chioye.
A.J. Jonah.
That's for the claimants. You appear alone.
With
A.J.
A.J.
Jonah.
Jonah, yes, sir. And E.N. Amadi.
A.J. Jonah. And E.A. Amadi.
E.N. Amadi. A.M.A.D.I. Yes,
Yes,
sir.
please. Yes, please. E.A.
Thank you,
Amadi for the claimants. All right.
Yes, sir.
Yes, and then for the defendants, I can't hear you.
Chidima,
Chidima,
my Chidima. Not
Chidima.
Chidima,
Ibe.
Chim. Chidima.
Okay, you appear alone. Or did you start the case from the beginning?
No, man, this from the beginning.
Who started the case from the beginning?
Grant to Esquire.
Grant Osu. You don't want his name to be here? Huh?
Grant Osu.
I think his name should be here too.
The matter now. Call your principal name.
Is that your principal?
No, my principal is Oka.
Okay, so I put Grant Osu. Yeah. Now,
Yes.
copies of this judgment shall be available for collection today.
Let's go,
And
please.
within the next 15 minutes, it will be online for you to read.
Okay, sir.
All
Let's
right.
go, please. Thank you, sir.
That will be all.
My Lord,
Cases, yes, please.
We appreciate my Lord's industry and hard work.
Good luck to you.
My Lord.
Thank you. Have a beautiful day. The court will
Thank you, my
rise.
Lord.
Hot.
Then
everything. Risk. That's what I'm trying to do. I've been trying to live.
Nah,
It's the first time. Okay,
No.
about this our that every start is to let us use the date on the first letter of by India.
Wọ́n kò tẹ̀ kó ti parí nǹkan tó ń pariwo oṣù.